Good evening. Welcome to the Tuesday, September 25th, 2007 special meeting of the Town of Orange Planning and Zoning Commission. Before we get into tonight's agenda items, I'd like to turn the floor over to Mr. Marino, and he can explain why we are here tonight at this time.
Thank you, Mr. Chairman. For those who recall, we were last here on September 18th, which was last Tuesday. I believe we ended somewhere around 11:30. Most of us did not have clear minds at that point, so we felt it best to adjourn at that point and come back with a fresh understanding of what had transpired that evening and what we were going to do to take certain corrective steps. On September 18th, there were a series of votes that were taken. There was a vote to approve a regulation change, which passed 3-2. There's no issue to reconsider that. However, from that point on September 18th, the Commission considered a site plan and a special permit out of order. In the first instance, the Commission should have gone to the application for re-subdivision because approving a site plan when it's uncertain whether or not there's a subdivision that might be approved or denied is improper. So in order to correct matters, and actually what happened that night was the site plan and the special permit got approved 3-2, but the Commission failed to vote on the waiver of the cul-de-sac extension on that evening, which is a necessary precondition to approving this subdivision because the cul-de-sac extension or the subdivision is dependent upon the cul-de-sac extension.
Is it okay if I stop here or just
Please.
ask a question? I seem to remember that the issue of the extension was put into the subdivision application. Is that?
Well, I interjected it in there
okay.
because it wasn't. If you look at the agenda, it wasn't listed specifically on the agenda as a specific agenda item. It was just a subdivision application.
Right. And in researching that, what I found, and I'll cite the Commission to section 1515 of Fuller's treatise on land use, which Judge Fuller specifically provides that before you consider a subdivision application, you must first consider whether you will grant a waiver in accordance with your subdivision regulations.
I wasn't even commenting on that. I just meant in terms of, I know we dealt with it as part of this subdivision.
And that was the problem. In the first instance, it wasn't on your agenda, so you dealt with something that was not on your agenda. But secondly, you dealt with it in a rolled format where it was there was confusion as to what you actually did. So in order to clarify the record and to do things in an appropriate order, I would direct you to the appellate court decision of Sharp v. Zoning Board of Appeals of the Town of Easton, which is at 43 Connaught 512. It's a 1996 decision that provides that a commission has the right to reopen a decision during the period of up to 15 days between the date of decision and the date of publication of the decision in order to correct matters. And I believe that, for those who actually want to go to the exact site, it's page 526 of that decision. I believe in order to correct matters, you should, Mr. Chairman, request a motion to rescind the vote on the subdivision application, as well as a motion to rescind the vote on the site plan and special permit, because to the extent that the subdivision application gets denied, it's an improper form to have a approved site plan and special permit, because you would simply stop at that point if the subdivision got denied. Okay. So by reopening, we're essentially turning the hands of time back to the point of last week's meeting where you have just finished voting on the regulation and adopting that.
And I take it that we should have separate motions and separate actions to rescind both of those votes?
Correct.
Is anybody prepared to make a motion to rescind the subdivision, the re-subdivision vote that we took on September 18th?
So moved.
So moved.
I'll second.
We have second. Any further discussion? There being none, all in favor of rescinding that vote signify by saying aye.
Aye.
Aye. Motion passes unanimously. Next, I'll ask for a motion to rescind the vote on the site plan and special permit application, which we voted on September 18th.
I'll move that.
We have a motion.
Second.
It's been seconded. All those in favor of rescinding that vote signify by saying aye.
Aye.
Aye. It's unanimous.
Okay. Mr. Chairman, then, in accordance with your agenda tonight, you should move on to the issue of waiver. Now, as I had intimated in my earlier conversation, before you move on to your subdivision application, it's incumbent on you to first consider whether you will grant a waiver in accordance with Section 382.23G4 of your subdivision regulations. Again, according to Judge Fuller's treatise on land use, waiver should be done before the subdivision application. Now, when you're considering waiver, the only issue that you're considering is whether or not you're going to be agreeing to waive the subdivision regulation as it pertains to that cul-de-sac. You're not taking into consideration anything else. It's my understanding that you've had input from fire and police, that input is part of your record.
Correct, that's in the record.
So at this point, I believe it would be appropriate for you to entertain, see if there's a motion to waive that provision of your subdivision regulation.
And again, when we deal with this, we deal with this completely separate from the re-subdivision, and we have to deal with that obviously on its own merits and not combine it with our thoughts with anything else, correct?
That's correct. And there's one further thing. The law requires that where a commission grants a waiver, it must state its reasons on the record for granting the waiver. So I presume that among the reasons would be the input from the fire and police to the extent that it's granted, but whoever makes the motion should incorporate the reasons for granting the waiver within that motion.
Is anybody prepared to make a motion to extend the cul-de-sac of Skyview Road beyond the 1,400-foot limit as per Section 38323G4?
I got a question. I don't understand what we're waiving.
In our regulation, we have a limit. I'll break it out to you so I can show it to you.
No, I understand. You're taking the cul-de-sac
Right.
out of what was denied previously, correct?
We're taking the cul-de-sac and dealing with it separately because just say for instance we had the re-sub application first, the re-subdivision of the land first. Obviously, if the person had his land re-subdivided and then found out afterward that he couldn't extend his cul-de-sac, then he wouldn't have wanted to go forward with that portion of it.
So if I'm not
Explaining that in layman's terms.
if I'm not mistaken, everything that we did last Tuesday is withdrawn.
We rescinded that, yes.
All-
We just-
everything.
Except the amendment.
Except for the
No.
zoning regulation.
We should amend that also, because if the cul-de-sac was not approved, we would never vote for that, correct?
The zoning regulation is completely separate from this
Separate from that.
issue. And when we're evaluating this, when we evaluate each one of these, if you recall when we first started the public hearing, we made the statement that while we were hearing the evidence altogether, that each one of those special permit applications, each one of those applications requiring a public hearing, had to be dealt with separately. So it's just a more efficient way to hear it instead of hearing pretty much the same thing over and over again with the different applications. But every time we have an application, we have to deal with it, or a motion on here. You have to look at that completely out of context. In other words, you have to, if this came on our agenda, if this was the only thing on our agenda, that's what you have to look at that as. So you have to say, look, what are the requirements to extend the street? Okay, we've got the letter from the fire, we've got the letter from the police. There's not a safety hazard. It's not as if there's going to be, a school at the end of this road or something of that nature. So we have to look at it as if we normally would and pretend that we don't know anything else that might happen as a result of this. We have to deal with it as a separate issue, and that's what we're instructed to do under 8.2 and I believe in 8.3 as well.
Correct.
So that's why we have to do this portion of it
I
first.
submit it.
Then he goes on to the other parts of it.
Right, and this is the problem with, it's not the problem necessarily, but the way that zoning commissions often proceed is you have all this information, so you kind of know what's coming. But in a sense, if this applicant had come in the first instance on just the waiver and just showed you their subdivision with a big 36-acre blank and 7 lots, you don't know what's going in the blank. It might be single-family homes, it might be dense homes. So, but all you're being asked to consider right now is whether or not you'll grant a waiver to
extend
that
that
cul-de-sac
cul-de-sac.
to accommodate those 7 lots. And then next month, again, now assuming you voted yes, next month they come in step number 2, which would be a site plan, because now or a subdivision. to create the 7 lots in the big lot. And
The next month is just an example, because we're going to move on to that.
So that's the example.
Right.
But here, what's happened, they've come all at once, which is common, because otherwise it would be inefficient. And so from an economic standpoint, it makes sense for everyone to come at once. But now when you're going through the process, really what the law is saying, you have to put blinders on and look at everything independent. You know, say, I don't really know what is gonna happen with this cul-de-sac, but the question is whether or not, under my subdivision regulations, does it satisfy the criteria under 38223G, and does it warrant a waiver? If the answer is yes, then you should vote yes. If the answer is no, then you should vote no. But that's really the question. It's not age-restricted housing or adult active community. That's not the question at this point in time. So, are there any other questions?
And we are, directed to specifically to deal with these.
And I cite the commission to section 1515 of Fuller, which specifically provides that if waiver requests are going to be made, they should be done before the application on the subdivision, which makes sense.
And I take it the commission has the authority to grant the waiver under the regulations.
Right,
Correct.
because we have
So
the letters.
it's not a, well, I mean, I don't mean whether we have the letters or not, but the regulations provide that we can grant
Yes.
that waiver. It's not something that goes to the zoning board of appeals or
No,
something.
it's 38223G4 provides the commission, upon a 3/4 vote of all the members of the commission, may waive the maximum length in subsection G1 and 2, provided, and then there are 3 subparagraphs. A, the fire marshal or his designee has certified that the proposed cul-de-sac street exceeding such length will not negatively impact upon the ability to provide fire protection to any of the lots along such cul-de-sac street. B, the chief of police or his designee has certified that the proposed cul-de-sac street exceeding such length will not negatively impact upon the ability to provide police protection to any of the lots along such cul-de-sac street. And C, the commission finds the proposed cul-de-sac street will not create excessive traffic upon any road which it intersects. So those are really the 3 things that you should limit your mind to at this point. That's what you're bound by your regulation.
And in this case, when we're considering this, because there is an existing subdivision that's been approved for the existing homes, and this will eliminate those other streets, this will actually reduce the amount of traffic on this street, because it's going to be a cul-de-sac only option to these homes.
I'm not sure I followed that.
Well, before this was kind of an interconnecting through the rest of this subdivision that's...
With the 28 single-family homes.
28 single-family
approved.
homes. So because now we're going to isolate this street and just extend
No,
this one
I-
street, it kind of, it's going to reduce the amount of traffic on this road, or the availability of traffic on this road. Is anybody prepared to make a motion? Is there any further discussion?
Well, I'd be prepared to make the motion, but I mean, we need to cite our reasons, we have to indicate what evidence we're relying on.
Right. Well, we're relying on the
I mean,
fact
so
that it's
is
going to
that,
reduce the
is that
traffic.
sufficiently part of the record?
I would refer to the information that's in the record. We're going to actually reduce the traffic on this street. We have the letter from the police chief and the fire chief stating that this is not going to pose a safety factor, a safety risk.
So these are all things in the record that speak specifically to the
Extension of this
criteria
cul-de-sac.
that need to be established before, as a basis for granting the waiver.
Correct.
Okay. All right. Well, now I will make the motion if.
Okay. We
Okay,
have a motion. Do you want to?
Second.
Okay, it's been
Any
seconded. Any further discussion? There being none, all those in favor of extending the Skyview Road cul-de-sac beyond the 1,400 feet limit as per section 38323G, all those in favor signify by saying aye. Aye. Opposed? Motion passes 3-2, which
No, you require a
supermajority there.
So,
Yeah.
Yeah. So that means the waiver does not pass, and there's no further business for you to consider at this point, because in order for the re-subdivision to proceed, it is requires for that 7 lots to be serviced by the cul-de-sac. Paul?
Yes.
Yeah, then the only question I had is I have to publish notification in the paper. Do I refer back to those votes, or do we have to go through the process of denying?
Do we have to have a reason for denial then?
Well, we still have pending applications, is what I'm
Well,
saying. If the last vote was invalid,
Correct.
which they rescinded,
There's no decision.
But they don't have to vote tonight. There is, correct me if I'm wrong, Van, this commission has 65 days from the close of the public hearing on which to act on the additional applications, and we're only in the 7th day, is that right? So the commission does not have to take action this evening
No, we're not
on
at
the
the 7th
subdivision
day.
or the
We've got to
site
be,
plan special permit.
well, that's after we close the public hearing, so we're not 7 days after, we've got to be,
Right, you have,
Well,
well, you have
still-
60, you closed the public hearing, I'm sorry, you're right, 21 days ago.
Right.
Right.
But,
So-
but the issue is that if the cul-de-sac is not going to be approved by a supermajority, which is what is required, then you never get to the other issues. So I believe that they're denied as a course,
Okay.
because,
just as we had to come back and visit these things again,
Right.
because we had to have them in a certain order, we
Exactly.
can't go forward because, that kind of stops the train.
So the commission does not have to take action?
no,
on
they
it?
can't take action. I think that we could go forward and vote, but the votes are,
But-
assuming for the sake of discussion that the vote on the subdivision is the same as it was last week, 3-2, that couldn't carry because your road is
Right.
not approved.
Right, so
we-
they don't
we
meet
couldn't
the
vote for the
subdivision
same reason we could-
requirement.
So
Same reason we took it out of order before.
essentially, you could not vote in favor of the subdivision, even though it meets your regulation. And for the sake of the commission, because I can predict what might come out of the applicant, I would just, again, cite the commission to the Supreme Court decision of Pansy Road versus Town Planning and Zoning Commission of the town of Fairfield, which provides that in reviewing a subdivision application, a special permit application, or a site plan application, the commission needs to consider the regulations, and if the proposed plan fits the regulations, you're acting in an administrative capacity, not in a legislative capacity, and therefore your discretion is on your subdivision, and your site plan is essentially of no discretion. On your special permit, you have limited discretion. So, in my opinion, the only issue here is whether or not where the record has evidence in it where there doesn't appear to be any fire or safety issue, whether or not it's abuse of discretion to deny the extension of the cul-de-sac, which ultimately would be a judicial determination. And to the extent that a judge were to determine that, then I don't think you would have the discretion to deny the subdivision, because clearly this regulation fits, since the regulation was drafted for this project. And with respect to the site plan, you'd have the same limited discretion or no discretion. Because,
I'm sorry, go ahead.
except that it's tied to a special permit, where if there were issues of public welfare and safety, you'd be able to have some discretion to whether it deny it or alter the project based upon that limited discretion. So obviously the vote is what it is, and it stands as a denial, and the parties, are left to their remedies.
No, we don't have to, the discussion before within 60 days is irrelevant, given the vote now.
Well, it's my interpretation that your vote is a denial of the project. Yeah. So, Paul, I would say it's a denial.
Okay.
You should issue letters of denial based upon the vote.
But the applicant, having had the zoning pass, can come in with a revised plan that doesn't require the waiver of the cul-de-sac line.
Correct. The applicant can come in, obviously, we're not going to stand here and give advice to the.
No, I'm not
But
intending to do that.
in my view, they would be able to either file a lawsuit against this commission because they can claim that in denying the extended cul-de-sac, you've acted illegally, arbitrarily, and capriciously, because the record is replete with evidence that there is no fire or safety issues. And the third criteria under 38223G4 is that you find that the proposed cul-de-sac will not create excessive traffic. You have a traffic study that shows the overall project's not going to create excessive traffic. So it seems to be, we would have a difficult time on appeal, but
Well,
again.
furthermore, this would actually limit the traffic onto that road, so it would clearly
Exactly, but again,
reduce the traffic.
that would be an issue on appeal. Or alternatively, the applicant could come forward with separate applications. Doing so, though, obviously, we'd have to come back and have new public hearings and go through the whole process again. But at this point, it's up to the applicant on how they want to proceed.
We're being done here. Do we have a motion to adjourn?
I'll move.
The motion has been seconded. All those in favor of adjournment at 7:25? Meeting adjourned.